Hello all. Welcome to the video series for preparation of the Indian Patent Agent examination. In this series, we plan to provide short videos on all sections of the Indian Patent Act 1970 to help applicants prepare for the Indian Patent Agent examination. The first session in the series is an introduction to intellectual property rights and various forms of intellectual property rights except patents, as we're going to look into patents in detail in the upcoming sessions. What are intellectual property rights? An intellectual property right is a right provided to the result of a creative effort from the human intelligence. The intellectual property is basically an intangible asset, which means you cannot possess it in its physical form. Based on the different forms of human intelligence and the different ways of expressing it, different forms of IPR exist. For example, if one has an idea which is a form of an expression, then a copyright. If it is an idea in the form of an invention or a scientific and technological advancement, then it is protected under patent. An idea in its quality and identity for a customer to identify a brand or a service, then trademark for the protection of the brand name. An idea in its appearance for the customer to look and feel a product, then it is design application. Generally, intellectual property ideas are for new inventions in order to encourage the work of art. Why would one want to protect their intellectual property? The most important reason for oneself to protect their intellectual property or an intellectual creation is legal monopoly. Legal monopoly is the monopoly means to exclude others from making or using one's invention or one's creation without his or her permission. Apart from having this ownership or monopoly, there are other reasons why one would want to protect their IP, such as creating a brand value for oneself or for an organization, avoiding infringement, avoiding free riding, and avoiding counterfeiting of products. Financial leveraging, wherein an intellectual property document can be treated as possessing a property document. Scientific and technological advancement of mankind, because inventions are shared to the public at large, as well as promotion of work of art. What are the various legislations on which the intellectual property rights are protected in India? The Parliament passes various acts or legislations in order to govern the intellectual property rights in India, such as the Indian Patent Act 1970, Industrial Design Act 2000, Trademark Act 1999, Geographical Indication Act 1999, the Copyright Act of 1999 are the few. Now, these acts lay out the rules, sections, and principles in the governing, in the granting, and processing of various forms of IPR applications. They also tell us the term for each of the protections, such as for a patent, it is 20 years, a copyright, 60 years after the death of the author, etc. Let us now look into few of the types of intellectual property rights. Trademark. A trademark is granted to a brand name or a trade name of an organization for its product and services. The word mark, that is the name of the organization, along with the color patterns, the logo, together can be protected under the Trademark Act. The protection for trademark is for the life of the organization. However, it has to be renewed for every 10 years. What are some of the rules one has to follow to get a unique trademark? The trade name or the trademark should not be similar or deceptively similar to your competitors or to an already existing trademark registered in the trademark registry. It should not cause confusion to the customer. Do not use common terminology describing the product. Do not use common designs, no offensive terms. Do not use any well-known trademarks. No official designs or words are also allowed. The most important characteristic of a trademark is it should be unique and it should describe the quality of the product or the service that is sold to the customer. There are a few strategies that one follows while creating a unique trademark, such as being creative, the most important aspect for any form of an IPR. Having clarity about the story that you wish to tell to the customer that is associated with your product or with your service. One other way to create unique words is to do into the roots of the words, understanding different synonyms or the origins and creating unique trade names. Creating mashups is also one other way in which you create unique trademarks. Designs. A design patent is granted to the external appearance of a product. A design should appeal solely to the eyes of a customer, and the uniqueness of a product is generally based on a visual test. There should not be any functional consideration, which means an external design should not have any functional utility value. A design patent is generally granted for 10 years and can be renewed for another 5 years for a total of up to 15 years. A design patent is generally used by a business in order to differentiate their products from their competitor products. There have been multiple cases in India and abroad wherein design patents have played a strategic role in order to space themselves apart from the competitors. Few examples of design applications include application for products which are sold in the market, plus jewelry design, etc. Configuration, surface shape and ornamentation are the important aspect of a design applications. Utility or structural features should not play any role in this design application. Copyrights. Copyrights is a form of IPR which is given to a creative expression of human mind in the form of original literary, dramatic, musical or artistic work. A cinematographic film, a sound recording are also protected under Copyrights Act. Copyright is generally given to the expression of an idea and not to the idea itself. The term of copyright is 60 years after the death of author. In order to avoid plagiarism of work, one should always acknowledge prior work, quote the source or references from whom they have derived the inspirations. Ideas, facts, recipes are generally not copyrighted. One of the most important application of copyright is the Indian Performing Rights Society Limited. The IPRS is a representative body of music such as the composers, lyricists or the authors. Under this, any particular composition that has to be used by oneself for commercial purpose has to be requested for a license or permission. The IPRS regulates the entire usage and royalty of musical and compositions. Other IPR such as geographical indication, trade secret and plant varieties. A geographical indication is generally granted to a product which is naturally originating from a particular place, manufactured in a particular place, including agricultural products. The origin or the manufacturing of the product should represent the quality or a reputation that is particularly to that individual region. In case if it is manufactured in the region, the process of the multiple process, at least one of the process should be from within the place of origin. Now, geographical indications are generally granted for 10 years and that can be renewed subsequently. The most important aspect of a GI is generally not given to an individual. It is granted to an association that is representative of the particular trade. The most common known geographical indications involve the Kanjivaram silks, the Tirupati Laddu, etc. In India, multiple geographical indications have been granted. These carry the GI tags such as the blue pottery of Jaipur, Chanderi fabric of Madhya Pradesh, Mysore silk of Karnataka, Kanjivaram silk of Tamil Nadu, Madhubani paintings Bihar are some of the few. A trade secret is an intellectual property wherein the invention are generally not shared with the public. For an IPR, the exchange of legal protection is for the disclosure of the invention to the public at large. Hence, if one decides to keep his intellectual property as a secret, he has to take reasonable efforts to maintain the secrecy. Some of the famous trade secrets are the Google search algorithm, Kentucky Fried Chicken recipe of the chicken, Coca-Cola, New York Times bestseller list. These are just a few. Few organizations and few individuals take a strategic decision in order to keep their inventions as a trade secret rather than disclosing it to the public for exchange of patent grant. Such key decisions can be based on the type of your invention, such as if you have a recipe, it is better to keep it as a trade secret rather than disclose it to a public for a patent grant. Plant breeders' rights are generally granted to farmers or to encourage commercial plant breeders to invest resources, time and labor to improve existing plant varieties. Now these ensure the production of the exclusive or a new variety of a plant or a new characteristic that a plant will exhibit. The novelty, distinctiveness, uniformity and stability are four important aspects for a new variety of a plant to be protected under the plant breeder's right. Based on the type of plant such as a crop or a tree or a vine, they can be granted up to 18 years of protection under this act. The rights also differ for a farmer, breeder and a researcher. With this, we come to the end of the session, an introduction to the intellectual property rights. Thank you for listening into the video. If you have any queries or comments, kindly comment below. Please subscribe for continuous updates on Indian Patent Agent exam preparation.